I'll call the meeting of the House Judiciary to order. Clerk, will you please call the roll?
Okay, good. Thank you.
For attendance.
Chair Lightner.
Here.
Representatives Bollin.
Here.
Wozniak.
Here.
Harris.
Here.
DeBoyer.
Here.
Johnson. Here. Schutte.
Here.
Carter.
Here.
Hope. Here. Breen. Scott.
Present.
Madam Chair, you have 9 members present. You do have a quorum.
Thank you, Madam Clerk. Next, I'm going to have Rep. Wozniak do a motion to approve the minutes from March 12th. Hearing no objection, the minutes are approved. Okay. Well, the next order of business is in regards to Rep. Wozniak's bills in the probate arena. It'll be House Bill 4033 and 4034. However, it's my understanding we have a substitute. And so I want to go ahead and just adopt the substitute to discuss it. So with that, I'll have Rep. Bollin make the motion to adopt the substitute. And Madam Clerk, will you please call the roll?
To adopt the substitute H1 to House Bill 4034, Chair Lightner.
Yes.
Representatives Bollin.
Yes.
Wozniak.
Yes.
Harris.
Yes.
DeBoyer.
Yes.
Johnson.
Yes.
Schutte.
Here. Yes.
Carter. Hope.
Yes.
Breen. Scott.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 0 passed. The substitute is adopted.
Thank you, Madam Clerk. With that, Rep. Wozniak, you and your guest, Mr. Speaker, may go ahead and go and testify on your bills.
Thank you, Madam Chair. This is not the first go-round with these bills. They were introduced last term. House Bill 4033 was passed 109 to nothing, and 34 was passed 102 to nothing. So it's not the first rodeo, and I know Rep. Breen is purposely absent because this is her favorite topic. So anyway, I'm very pleased to be before you today to speak in support of House Bill 4033, which seeks to create the Unitrust Act, as well as House Bill 4034, which seeks to provide technical fixes to Michigan's tax code. While I'm pleased and proud to be the bill sponsor, this legislation has been finely tuned and championed by the stakeholders and my office. So thank you to all of you who have contributed to the versions of the bills you have before you. Both bills were introduced last term and have overwhelming support, as I mentioned earlier. Now, given that we are fortunate enough to have Mr. James Spica, whose legal practice is dedicated to representing and advising individuals and institutions with respect to complex trust planning and similar issues, with the permission of the chair, I would like to ask him to provide a more detailed technical explanation of the impact of these bills.
Thank you, Representative Wozniak, Madam Chair. The thing I'd like to emphasize is that the impression given by the text of 4034, House Bill 4034, and I'm afraid the substitute that is being adopted today is that these two bills have very much to do with one another. And that impression is given by the enacting section that appears on page 4 of the final version of the substitute. They don't have to do with one another. That enacting section is an error, and there's no reason for 4034 to be tie-barred to 4033. The two acts operate independently because they concern very different fields. 4033, the Unitrust Act, is an attempt to help trustees who wish to invest trust assets for a total return, which is the modern fiduciary investing format, to reconcile that attempt to generate a total return for the benefit of the beneficiaries with her fiduciary duties of loyalty and impartiality towards the beneficiaries when a trust that was whose terms were designed in the 50s or 60s speaks in terms of income beneficiaries and remainder beneficiaries. The trustee, to seek the largest total return for the beneficiaries, will be presented with opportunities to invest in stocks like Apple, which is a great appreciator and pays no dividends whatsoever. That would seem to be a breach of duty to income beneficiaries styled as such in older documents that use that terminology. The Act will allow a trustee who is energetic enough in seeking economic returns for beneficiaries to encounter this tension with the trust instrument under which she's administering the trust, to elect to treat the trust as a unitrust, which means making distributions based on the value of the trust assets periodically determined without regard to how much income in the form of dividends, royalties, interest, and so on the fund is actually earning. So this is facility that will put, if enacted, bring Michigan in line with 36 other states in the union that have adopted some form of unitrust statute. And it will do so without increasing the burdens of trustees, because the Act specifically provides that a trustee is not under a duty to utilize the Unitrust Act or to consider doing so. So this is for trustees who find themselves in the bind I've described, but it doesn't push any trustees into that bind as a result of enactment. As Representative Wozniak has described, House Bill 4034 is technical corrections to the Uniform Statutory Rule against perpetuities. The uniform rule works hand in glove with Michigan's most recent perpetuities reform, which is the 2008 Personal Property Trust Perpetuities Act. In 2022, the latter act was amended so as to allow beneficiaries of trusts administered under Michigan law to take advantage of a feature of federal income and estate taxation known as the step-up in basis. And that 2022 amendment to the Personal Property Trust Perpetuities Act changed the structure of the hand slightly so that it remains for House Bill 4034 to change the glove and to make the receiving end of the reference in the Uniform Statutory Rule to the Personal Property Trust Perpetuities Act easier for practitioners who are not like me, not like Representative Wozniak, who understand how these two acts work together, to understand how they do. And so I'm happy to be here today on behalf of the Probate and Estate Planning section. I am their immediate past chair. I need you to note, however, that the section is not the State Bar of Michigan. It is a voluntary association of practitioners who are members of the State Bar of Michigan who specialize in probate and estate planning. I am also a uniform law commissioner appointed by the Legislative Council as a delegate to, as a Michigan delegate to the Uniform Law Commission. Both of the acts I've been talking to you about, both of the acts reflect uniform law deliberations. The uniform the Uniform Statutory Rule against perpetuities is a product of the Uniform Law Commission's promulgation in 1987, enacted in Michigan in 1988. The Unitrust Act is based on Article 3 of the Uniform Fiduciary Income and Principal Act. And its adoption in Michigan will, as I say, allow trustees to elect unitrust treatment in line with the trustees in 36 other states. So I hope you will vote these bills out of committee when the time to vote comes. And I thank you, Madam Chair, for the opportunity to speak to these bills today. Thank you.
Thank you, Mr. Speaker. And, to make it kind of simple for simple folk like me, bottom line is this is just another tool in the toolbox. It's not mandated that they follow this process or, through the unitrust and the perpetuities, correct? It's an additional tool in the toolbox.
It is indeed. The tool is required by federal taxation law with respect to the rule against perpetuities. Many
Okay.
states would cheerfully do away with the rule if the federal government, through the U.S. Treasury, had not reached out to local law regulation of perpetuities as a way of determining tax effects.
Okay. Thank you. We have another question. Rep. Breen.
Thank you, Madam Chair. Rep. Wozniak, I'm wondering, this is a difficult concept. Can you explain the rule against perpetuities?
I don't think time would allow us that. All right.
Okay.
But thank you for the question, and thanks for coming for this presentation.
Wouldn't miss it for the world.
Okay, I'm glad you were being facetious. Okay. Well, with that, I have, these are mine. Yeah. Yeah, the only card I have in here was in regard to Jim Spica in support of the bills, and obviously he also testified to the bills. All right, well, we're going to go a little out of order now. So we're going to have Rep. Hope come down in regards to House Bill 4045, in regards to the SLAP issue. So go ahead, Representative.
Thank you, Chair Lightner, Vice Chair Bagol, Vice Chair Carter. I want to thank the chair, first of all, for taking this up so soon this term. This is common sense legislation that's widely supported, and I'm hoping that we can make this law this time around. So what this does is it would allow a court to dismiss early on what are known as strategic lawsuits against public participation. If you've never heard of those before, you're not alone, but the people who have heard of them feel it deeply and have suffered financially and emotionally. What they are is retaliatory suits that are aimed at silencing, intimidating, or punishing someone who speaks out on an issue of public interest. And I do have some examples to illustrate, but before I get there, I want to just further elaborate that bad actors, usually with ample resources, file these lawsuits knowing that the defendant doesn't have the resources to actually fight the case. So what does this mean as a practical matter? Well, I've kind of an aside, I've heard more about this legislation, I think, coming from myself than I've heard about any other legislation I've worked on. It's right up there anyway. So an example, last term I talked with a person from Southeast Michigan who was excited to see this legislation introduced. She's a retired person who's interested in public affairs in her community, and she and a couple of her compatriots had posted some questions about her local government's dealings with a private entity. This is still in litigation, so I have to be a little bit vague. So all they did was raise a question, posted it on Facebook, I believe, and the private entity at issue, who had not been defamed or had their reputation disparaged or anything like that, it was a legitimate question about the government's interaction with this group, sued for defamation. So now this retiree, even though there's a case against her with no evidence to support it, she has had to pay for discovery costs, to get to the certain point where she could seek dismissal. What this legislation would do would allow a dismissal earlier on, so within 60 days of the lawsuit being filed. If you can come forward and show that there's not prima facie evidence to support the claim, and the court agrees with you, then it will be dismissed, and in some instances you could also get attorney fees. Now, if you're concerned that legitimate litigation will go by the wayside because of this this new procedure, there are a lot of safeguards in place. One being that there's a right to an immediate appeal. So, so that is a fail-safe in there as well. And I'll have, if you don't mind, Chair, the Caitlin Wolf from the Uniform Law Commission talked to us a little bit about the framework of this law and get into the legal details. But I guess the only thing I would add before we turn it over to her is that this is the third time I've introduced this legislation. And last session, this passed the House 100 to 8. It just didn't make it through before the end of the session. And one thing that you might also find interesting is that at the national level, this is from the Uniform Law Commission, so this has been adopted in other places. At the national level, this has been supported by groups as varied as National Right to Life and the ACLU, Americans for Prosperity, and the League of Conservation Voters, among many others. Writers, artists, scientists all support this legislation. And with that, with your permission, I'll turn it over to Caitlin.
Thank you, Representative. While you're doing that, I will call on Caitlin, but I'm also going to read in the card. She did put in a card of support and wanting to speak, obviously, on Zoom, and like I said, in support of House Bill 4045. And Caitlin, just so you know, we do have another set of bills to work on today. So time is kind of the essence. So if you could keep it to a few minutes, that would be ideal. Thank you.
Absolutely. Thank you so much, Chair Lightner, Vice Chair Bagol, committee members. I will keep it brief. My name is Caitlin Wolf, and I'm testifying in support of the bill on behalf of the Uniform Law Commission. It's been my pleasure to work with Representative Hope and her coalition in Michigan on this bill over the last few years. She mentioned that this bill is all about dealing with the problem of strategic lawsuits against public participation, or SLAPs, a very particular type of frivolous lawsuit. This bill would, in essence, create an expedited process to deal with SLAP lawsuits and hopefully to prevent them from happening in the first place in Michigan. So at its core, what the bill does is it creates an early off-ramp. So if somebody is sued for speaking out in a legislative hearing about a bill or writing a letter to the editor about, an issue going on in their town, if they're sued for that conduct, they can file a special motion with the court to get their lawsuit in front of the judge early and to have it evaluated. If the judge thinks that this is one of these particular types of frivolous lawsuits, the judge could dismiss the case far earlier than the judge could if this were to follow the normal litigation process. Again, this bill is all about kicking out lawsuits that don't have merit and about decongesting court dockets, allowing legitimate suits where somebody is seeking legal redress to move forward. By way of background, 36 states have some version of an anti-SLAP legislation like this on the books. Unfortunately, Michigan is one of the states that does not have protections in place for its citizens. The Uniform Act that this bill is based on has been enacted into law in 11 states so far, and we're working in another 10 this year. As Representative Hope mentioned, this is a bill that has enjoyed wide bipartisan support. Everybody seems to agree that it's essential to safeguard our constitutional rights. and we don't want to discourage public discourse about the issues that affect us in our communities. I will keep it at that. Thank you so much for giving me the opportunity to testify, and I would be happy to take any questions the committee has.
Thank you, Caitlin. We're going to move on to the next speaker, and then we'll do questions in just a moment. So if you would stand by, that would be ideal. The next card that I have is in regards to this House Bill 4045. Wishes to speak. Did not take a position on the bill, or at least let us know. Peter Philippus, are you on the phone?
Yes, hello, good morning.
All right. And Peter, I don't know if you heard me say it earlier to our other speaker. If you could just keep it to a couple of minutes, that would be ideal.
I certainly will. Thank you.
Thank you.
My name is Peter Phillips, and again, I'm soon to celebrate my 64th birthday, and therefore, as an elderly man, I value the resource of time above all else. When I now reside in New York City, and during my last visit to Michigan on January 2024, I visited the congressional offices in Lansing of many members of this committee, including Representative Hope. And my desire is driven to see much reform made in Michigan through legislation, largely also based on what happened to me, which should not have happened to me. First and foremost, I would like to congratulate the new chair of this committee, Representative Lightner, for graciously allowing me to speak today, and to compare and contrast. During 2 consecutive weeks in June 2024, the former chair of this committee, and that would be Representative Kelly Breen, adamantly refused to allow both myself and the majority of the members of our community rights activist group the opportunity to testify in opposition to House Bill 5724 and exercise our civil rights to free speech. What a surprise that Kelly Breen was also the sponsor of that bill. So in conclusion, and I'm keeping this very brief, as a lifelong Democrat, I am glad that new broom sweeps clean here in this committee, which needed a new chair at the helm.
Sir, can you keep your comments germane to the bill, please?
Yes, I am. My problem is when somebody wishes to testify on a bill, which what I attempted to do last year and my fellow community rights activists attempted to do on 5724, we should not have been denied our rights to do so by the former chair of this committee. And that is why I asked to speak today, because again, we should not have been denied our First Amendment.
Okay, can you speak to the bill, please, sir? I'm going to ask you one more time. Please speak to the current bill and not about the former processes, please.
Right. Well, again, that's why I asked to speak, and that's all I have to say is that I appreciate your courtesy of allowing people to speak and not silencing us. Thank you very much, Representative Lightner.
Thank you, sir. And with that, we're going to go ahead and take questions. I know Rep. Breen had a question. Do you guys have any questions?
Yes, Madam Chair, thank you. Representative Hope, I'm wondering if you can give an example that would help the public sort of really understand how this bill would apply, or if, in particular, if you are aware of anything that happened in Michigan.
Yes, the case I mentioned earlier is from Michigan. The retiree who had posted on Facebook about her town dealing with a private entity. If this had been in place at the time, she could have filed for this off-ramp motion, so to speak, early on, within 60 days of the suit being filed, when it was apparent that there is no prima facie case of defamation. Instead, she's forced to hire an attorney, defend herself, go through some expensive discovery, and it's costing her a lot of money to defend herself. The plaintiff has resources galore, so they're not concerned about paying an attorney to go to court or to sit through a deposition or what have you. So it really just levels the playing field. And it also has the function of protecting people's right to free speech. We're all entitled to complain about our government, to complain about issues in the public sphere, and so this has the side benefit of that. There are a number of other cases involving environmental issues, sexual assault victims. There's one case involving the Saugatuck Dunes, which has gotten some attention over the past several years, with the developers suing a conservation group. It levels the playing field, and it prevents people who have really done nothing wrong other than exercise their First Amendment rights from having to pay thousands and thousands of dollars to hire a lawyer, to pay for discovery, and all that's currently required before you can seek dismissal.
Representative Johnson.
Thank you, Madam Chair. Quick question here. Why is the government exempted, if I'm reading this correctly? Page 3,
Why is
14 to 19, if I'm reading it correctly.
Well,
Section 1.
this would just so say that you complain about your city council. This would prevent the city council from turning and dismissing dismissing a case that you had brought against them. It's a little bit higher of a standard for the government, so that's why.
Rep. DeBoyer.
But what if the reverse is true? What if it's the government bringing it against you?
Well, this allows the early motion to dismiss if you bring it within 60 days, if you feel like you're being harassed by the government. And I do have actually a very local case of that, where folks felt like their city was harassing them, and they were prevented from getting this early dismissal because we didn't have this in place. So yes.
Right, so yeah, that answer. So it doesn't exempt this from occurring if I'm a citizen and I'm making the claim.
Correct.
It does not exempt it. It only exempts it the opposite direction.
Correct.
Okay. All right. Thanks for the answer. I appreciate that.
All right. I don't see any further questions with that. I'm going to read in cards
Thank
in
you.
regards to the bill. House Bill 4045 does not wish to speak. Supports the bill is Josh Levin from the Motion Picture Association. Supports the bill, does not wish to speak. Mitch Albers, Michigan Association of Justice. Supports the bill, does not wish to speak. Kyle Zawicki, ACLU of Michigan. Does not wish to speak. Supports the bill. Heath Lowry, of Michigan Coalition to End Domestic and Sexual Violence. Nathan Triplett of the State Bar supports the bill, does not wish to speak. The Sierra Club supports the bill, does not wish to speak. Michigan State Employee Retirees Association supports the bill, does not wish to speak. Michigan Unitarian Universalist Social Justice Network supports the bill, does not wish to speak. Catherine Bussard of Salt and Lake Global opposes House Bill 4045, does not wish to speak. Mitch Rice, a Lansing resident, supports the bill, does not wish to speak. Okay, well, thank you. Well, with that, we are going to go ahead and move on to House Bills. Well, my House Bills. One's mine, one's Rep. Bollin. It's House Bill 4255 and 4256. I'm gonna switch out, so I'm gonna come up here. Representative Bollin's back desk is gonna come up here, and then I would ask that Dave Gilbert, Mike Hurst, and Julie Reisner all come up here. I'm gonna sit here in the middle, and we will go at ease for just a moment to switch out, and we'll take testimony. All right, Brian.
The committee will come back to order, and Representative Lightner, if you want to introduce your guests and go ahead and proceed with your testimony.
Sure. So with me, I have David Gilbert, the Calhoun County prosecutor. I have Mike Hurst of Andy's Angels and Julie Reisner, another resident in the Jackson community. And then I have Jessica, who is Rep. Bollin's back desk right now, her legislative director. She's going to fill in and read the representative's testimony, and then I'll add to it.
Good morning, Madam Chair and members of the committee. Thank you for the opportunity to testify on House Bill 4255 and 4256, which would amend the Criminal Procedure Code and the Public Health Code. This package of bills creates a new category of controlled substances and creates a higher penalty for heroin, fentanyl, carfentanil, or any derivative of heroin, fentanyl, carfentanil, or any opioid, and revises these penalties. We know that these potent drugs are surfacing as frequent killers of so many in our communities. Fentanyl is contaminating heroin, meth, cocaine, and fake prescription drugs. Throughout Michigan, there were 2,931 overdoses in 2023. That is the last year that has been recorded. Synthetic opioids are primary drivers of overdose deaths in Michigan. Prescription drug addiction and fake prescription drugs are taking their toll on Michigan families. We must do whatever we can to stop this trend. Many of us know someone whose life has been completely shattered by these horrible drugs. We may also know individuals who have risen out of the addiction and want to stay on the straight and narrow and drug-free life. We can combat this drug problem by increasing the penalties and putting these bad actors away. Our drug courts have been successful in helping people beat their drug habits for lower classified drugs, even some Scheduled 1 and 2 drugs. We want to support these successful efforts, but we must do something to stop the penetration of these fatal drugs throughout society. We do not want to offer the courts, including our judges and prosecutors, the flexibility they need to ensure we are meeting our goal of getting these drugs off the street and making sure the offenders pay for their part in these horrendous crimes. Thank you again for the opportunity to address the committee, and I look forward to your support to ensure we reduce the fatal effects and damages these horrible drugs have on our family and friends.
Thank you, Jess. So I just want to give a little background. This is, I think, the fourth time that we've had our Jackson residents up here testifying, the fourth session. They've been here every term I have been here. Granted, it wasn't me before. It was Rep. Alexander being a champion for this. Fortunately, over the last few months, we have done a lot of work in kind of reviewing these bills, trying to figure out why they aren't moving, what we can do to make them move, because I would bet that almost every single one of us have a story in regards to fentanyl and or heroin. And I would bet also a lot of us are sick and tired of people getting a slap on the hand for peddling these drugs, whether it be it directly or indirectly, because it's laced, they're buying it on the black market, whatever the circumstances may be. So in reviewing these bills, not only did we increase penalties as far as a maximum goes, we actually kind of went back to an old way of thinking and put in some mandatory minimums. We also put in mandatory minimums for people selling to minors. You might ask yourself when you actually read through these bills, well, what about the people that didn't know that their product was laced with fentanyl? Well, here's a novel idea. Don't frickin' peddle drugs. It's that simple. These people are killing people in our community. They're getting slapped on the hand because they can easily go through a sobriety court because they're not necessarily the ones doing the drugs. They're just peddling them. And I think the prosecutors and sheriff's department, state police need the tool in their toolbox to actually pick these people up that are, going through our corridor. I have the 94 corridor, so I have the Battle Creek area. I also have, the Jackson area. And, that's a huge corridor for the cartel, gangs, and, they're all doing and peddling, or not doing drugs, but they're all peddling drugs. And I want to be able to keep these people off the streets longer and a first-time offense. I just think it's that serious, and we need to make sure people know that we're taking it serious here in Michigan again, and we are going to penalize their crimes. So with that, there's also a schedule in your packet that kind of shows what the current sentencing guidelines are and then what the proposed new ones are. Also, I want to talk about a difference. So some of you may be familiar with the legislation from the last couple of terms. changed the different schedules. So, in theory, if you just, it lowered the penalties for like cocaine or something. It doesn't do that. We actually started a new classification, a new schedule for that. So it keeps all those penalties still the same, for regular heroin, cocaine, all those other schedules. We started a new one specifically for fentanyl or a derivative of fentanyl. And with that, I guess we can move on to our prosecutor.
I'm David Gilbert. I'm Calhoun County Prosecutor. Calhoun County has about 136,000 residents. It's the 17th largest county in the state of Michigan. Yet it's number 3 per capita for overdose deaths in the state of Michigan. It's number 4 in overdose survivors, emergency room survivors in the state of Michigan. I've been an attorney for 36 years. I haven't always been prosecutor. I started out as a defense attorney. I became an assistant prosecutor, then as a defense attorney again, and then I was elected to prosecutor and took office in 2013. I've seen a big change in drugs. I used to be not a big fan of mandatory minimums just because we were usually getting the low-hanging fruit. But things have changed right around 2012 when fentanyl hit the streets and car fentanyl hit the streets. You've got police officers that were scared to actually touch drugs, test drugs, things of that nature, just because of the fentanyl. Now, some of that was overblown, but the bottom line is most of our drugs today, 78% of the drugs that we deal with have fentanyl in it. To say, I didn't know there's fentanyl in it, is really difficult to say these days when 78% of those, the drugs that we find have fentanyl in it. About 75% of the overdose deaths in our county, and probably the state too, have fentanyl in the drugs that are being used. Many times our victims, our drug users, don't know that they're using fentanyl, but others do because fentanyl gives a really, really good buzz at a lot less price. But car fentanyl and fentanyl in particular are basically the primary movers and the killers today in the drug culture. Since 2021, I believe overdose has been the leading cause of death in the United States. And it's the leading cause of death in Calhoun County, I believe. So I do support this legislation. I don't know about the heroin. Heroin is probably the number 8 killer of all the drugs, but fentanyl and car fentanyl are the number 1 killers. So I do support this legislation because we got to start saving people. If it wasn't for naloxone and the Narcan, our death rates would be a lot higher. And I got to tell you, these people that are being saved, the people that survive the overdoses, that's only because of the Narcan. And, if you have any questions, I'm free.
Good morning. I'm Michael Hurst. My son passed from a heroin overdose in 2010. Since that time, I've given public seminars all across the state of Michigan, from school kids to doctors. I also worked with former Governor Snyder and present Governor Gretchen Whitmer regarding Andy's Place in Jackson. It's the first of its kind in the nation. It also won the 2020 coveted Edison Award in Washington, D.C. for Best Affordable Housing Project in the entire nation. We teamed up with the treatment courts on that project, and it's just been working fantastic. I only tell you all this today because I want you to know I'm just not another parent that's coming up here seeking vengeance. I have spent since 2016 till today, which we're on phase 2 at Andy's Place, on my own dime. That's how strongly I feel about this. And I was just trying to give myself a little credibility to know that I'm just not another parent coming in here that wants to destroy some drug dealer out there because their son passed away. We're looking at a serious situation here. 100 and some thousand people die every single year. 75% of those people, it's with fentanyl. Now we have the drug cartels making their own pills, whether it's Oxycontin, whether it's a Xanax, whether it's a Percocet. They make them look exactly like them. The drug is just fentanyl with a cutter in it. 60% of the drugs on the streets right now are comprised of the drug cartel making these fake pills. So now we're not just getting people who started using drugs, got hooked on drugs. Now we got people that have never used drugs before dying. We got young kids out there. Somebody offers them a pill. They look at it and say, wow, it's a prescription pill. It's okay. It's not okay. And the other thing you need to know is these people out here selling this, they have no heart. They're the coldest people I've ever met. And I know both sides of the story here. And they could care less whether you live or die. To you, they're a customer that's a slave to them. They know that every 12 hours you're going to be calling them up because you're going to go in withdrawals. And they make their living doing that. Now, part of government is to protect the general public. And we have to decide, are we going to try to protect your kids, my kids, our families? Or are we going to try to protect the people that are out there destroying those people I just mentioned? So I am in full support of this bill, 100%. I can't tell you how many times I've gotten somebody clean, and it takes about 2 years. And in between that time, as soon as a dealer finds out where they're at, how they can get a hold of them again, they're calling them up. Hey, I heard you've been good for a while. Well, and I've got some stuff here for you, and it's really good. And I must tell you, once somebody does get clean, and somebody makes that call to them, their mind starts to go back to day one. And if you know anything about substance abuse, with the fentanyl, the heroin, any of the opiates, you build up a huge tolerance to it. So whatever you took, whatever amount you were taking the day that you finally got clean, went to jail, whatever the case may be, and I do advocate jail. I've gotten so many people, first person that works for me, he spent a year in jail. He's been clean for 15 years now. So don't think that jail is some bad thing. We use it to our advantage all the time to break the cycle. So I'm in full support of this bill. I'm in full support of all those people out there that are suffering, that are sick right now. I'm in support of all their families, and I'm sure there's no question in my mind, every single one of those families are in support of this bill. And we don't stop this cycle with some kind of new legislation that really drives a point home that, hey, we're not going to tolerate that in this country, in this state. That's what we should do. And, Sarah mentioned, well, maybe somebody's going to come forward and go, well, I didn't know I was selling this. I didn't know it had fentanyl in it. I thought I was just selling heroin. Maybe I thought I was selling cocaine. It was actually cut with fentanyl and it killed the person. How was I supposed to know? Well, I got to tell you, there's a test kit out there. So I would suggest that those people that want to cry the blues out of there, take that tax-free income that they just made, take all that tax-free income they've been making for the last 10 years or whatever the case may be where they've been doing this business, and go buy themselves some test kits. If they can't do that, I don't know what else to tell them. So, I'm in full support of this bill. I know that other states are proceeding in the same fashion that the state of Michigan is, and I also know that the state of Oregon kind of went the other way, and they decided, what a disaster. So here we are today, and I hope you read that bill, read it closely. I hope you understand the information. If anybody has a question that they want to ask me about this subject, I would be more than happy to answer today or any day. Thank you very much.
Thank you, Madam Chair, committee members. I'm very humbled to speak in front of you today and share a little bit about our family. We first reached out to Rep. Alexander in 2019 at an Andy's Angels function. My husband asked her, isn't there something that we can do about fentanyl? It's killing our loved ones within our community. At that time, there were 70,000 deaths a year. We are far more educated. We're in school speaking. And today there's 100,000 a year. It's not getting any better. A little bit about our family. I've been married almost 50 years. We have 2 children, 42-year-old daughter who's a small business owner in Jackson County, and our son. We are you. Our son was an excellent student, Chris Reisner. He was an awesome athlete. He was a scholar athlete. He had 10 offers to play college basketball. Never was in trouble a day of his life. One day, someone passed him a Vicodin in the hallway at school. And then he had a few instances of injuries. He was in the hospital with spinal meningitis. At that time, 2007, 2008, the pharmaceutical companies were still saying 1% chance of addiction from these pain pills. As a parent, we taught our kids, you don't do drugs, you don't drink and drive. We were you. Never knew we had to warn our kids about a prescription. But our son, struggling with depression, felt comfortable and normal when he took prescription pain pills. And he continued to take them through college until he dropped out of college. We didn't know he was taking them. We didn't know he was now getting them on the street. That addiction led him to reach out to us about 4 years later, needing help. So, being a mom, well, I can fix this, because that's what we moms do, or parents do. We got him into rehab. He tried four different attempts at rehab. He tried biofeedback. He tried hyperbaric chamber treatment, because using opiates kills your dopamine level. So we were trying anything to get him well. He tried everything to get himself well. He even went as far as to do ECT treatment, which is like the old shock therapy treatment. 10 treatments of that to fix the depression, because you have depression and then you have addiction. You fix one, you try and fix the other. That didn't work either. His addiction finally led him to heroin. In between bouts of being well, we connected with Mike Hurst. We needed help. We didn't know anybody else that struggled with this. And Mike and Chris formed a dear friendship. And Mike took him to all our schools, in front of doctors, in front of state police, and they spoke together, trying to make a difference in these kids. My son would say, gosh, if one person would have told me, if one kid would have ratted me out to my parents that I was taking these pills, I wouldn't have gone through what he's gone through or what he's put his family through. So Chris was trying to get his dealer off the street, and Mike connected him with JNET, our Jackson Narcotic Enforcement Team. They were going to do a sting operation. He shared with Mike that he thought the only way he was going to be able to quit using drugs was to get his dealer off the street. So he wore a wire. He went to the police post first. They searched his car. They gave him the money. He went into this guy's apartment, made a buy, went back to the state police post, gave him the drugs. Later that night, that guy was picked up and arrested. Well, about 4 days later, the guy bails out. He's repeatedly texting our son, I need bail money. I got arrested. I need bail money. I got some good drugs for you. Come see me. And our son would share those with us, his text messages. This guy's just hounding him. So at some point, it was found out that our son was the one that ratted on him. So he was jumped downtown Jackson and beaten by 4 of this drug dealer's family members. He was put in the hospital, broke his jaw, broke his nose. And so Chris prosecuted the 4 of them. He had to find them. He had to find out what their real names were. But he gave all that to the prosecutor, and they were all prosecuted. 3 of them went to prison. And the dealer, in the meantime, they were prosecuted for witness intimidation. The dealer hadn't quite gone for his trial yet. 3 of the 4 went to prison for that. They got anywhere from 3 to 7 years. I think the maximum was 10 years for witness intimidation. The dealer was found guilty. He got 3 years. That was the minimum. It was like 3 to 8 years, whatever it was. That judge gave him the minimum. And our son always said, the dealer told him, I make enough money that it's worth going to prison for a few years. So I got plenty hidden away. I can come out and start selling again. So Chris went through, for the next several years, in and out of rehab, still fighting the disease, still speaking with Mike. Mike gave him his purpose in life, because oftentimes he'd just stay in bed. It was safer in bed. Our son had been clean for about 2 years from opiates. When my husband went in one morning, the day before Thanksgiving, to see if he was living in our home. He had like a whole separate, like a studio apartment at our house. And so my husband went in to see if he wanted to go have breakfast with him that morning. So he walked in and found our son dead in his bed. And the day before, he and I had gone shopping. He was my shopper. And we were going to Disney in 2 weeks for his little niece's, our granddaughter's, 2nd birthday. And we were all going. And he had all his clothes laid out on his futon, chair, couch, ready to pack. He came out after he was done with everything and said, "Good night, I love you." His last words to us. And my husband had to find him the next day. It's horrible. He was honored he was part of our Jackson County Heroin Task Force, which Jerry Jarzinka started several years ago. He worked side by side with Congressman Wahlberg, speaking, and the meeting was held maybe 3 or 4 days after Chris's funeral. They have a drug summit meeting once a year, and Congressman Wahlberg honored our son on the House of Representative floor in Washington, D.C., for the work that he had done in our community. It took 6 weeks before we found out what Chris died from, because he'd been clean for 2 years. We thought maybe he had been on Xanax because he had so many trials that he'd had to witness or give testimony to. It was scary for us, and it was very scary for him, but he did it. He always said, we have these bands made, and he always said he took the saying from Mike, but he used it more proudly. To look the other way is to give permission. You can't look the other way. We found out 6 weeks later that he had died of a fentanyl overdose that was laced in the heroin that he had purchased. For some reason, he needed something that day. We don't know why, after 2 years. The person that got it for him was texting him throughout the day, "Are you okay? Are you okay?" Because she knew he hadn't used in 2 years. Found out who she was. She was arrested. She was a user. He bought what they called a bindle. Bought one for her, one for him. I didn't want to see her go to prison, but she was arrested for delivery causing death. We wanted the dealer behind her. She was just an addict. So we worked with the prosecutors. She was able to testify against the dealer. And her sentence, she did about a year. Her sentence was dropped, or her charges were dropped to delivery. However, because the dealer was also arrested for a fentanyl charge just prior to our son's death, they prosecuted that case first and then would bring charges against our son's case next. The prosecutors advised us they would run concurrent, I believe, so that if he was found guilty of our son's death, he wouldn't serve another day in prison. So we said, okay, we're going to back off this case, but we supported the original drug case that he was on. That sentencing, believe it or not, was the same judge that 3 years earlier sentenced the dealer that our son wore a wire on to the 3 years, we got the same judge. The amount of time was 11 to 18 years that this guy could be sentenced to. And we all know she gave him the 11. And he'd already been in, because it was COVID, he'd already been in 3. So at that point, he was only going to serve another 8 years for murdering our son. Now, it wasn't those charges, but he probably would have been found guilty because the girl was going to testify against him.
Ma'am,
I'm so supportive of this bill.
our hearts go
And
out
I'm
to you
done.
today. Yeah.
Thank
Okay.
you. I do appreciate
I just
that.
needed you to.
I was wrapping that up.
Okay,
Yeah,
very good.
sorry. But yeah, that's why I'm so, this fentanyl's killing our family in our community.
Thanks for your commitment.
Yeah, it's hard to say
this.
that much in a short
I can
time.
imagine.
I appreciate your patience.
Okay.
Thank
Looks
you.
like we do have a couple questions from our members. Representative Breen.
Thank you, Mr. Chair, and thank you for sharing your story. Chair Lightner was right. We all have a story. I lost, my brother lost his best friend. And I know hopefully in a few weeks we're going to take up some bills about xylazine, which is now being found in almost every sample of fentanyl out there. My question is for Chair Lightner. And to be clear, I don't have any problem raising the penalties for fentanyl, heroin, or any of those derivatives. I'm a little concerned about some unintended consequences with some of the non-opiate drugs, and I'm wondering if you would be willing to look at some amendments that would either remove marijuana from this or some of the non-opiates, or perhaps wait for the Sentencing Commission to come up with some recommendations.
Well, to be clear, do you mean like marijuana laced with fentanyl? Because it's anything laced. That's what. So it doesn't raise the penalty. It keeps the penalties the same for things like that. It's if there's a derivative of fentanyl on those products when they have them, they're dealing possession, then it's under the classification, under these new classifications. But it has to have some sort of derivative of fentanyl on that product or in that product.
Okay. It could be perhaps I was just misunderstanding the bill correctly, and I'd be happy to talk with you more about it to make
Sure.
sure I got
Thank
it down
you.
right. Thank you.
Representative Wozniak.
Thank you, Mr. Chair, Mr. Prosecutor. Just questions on the different penalties are available to you to work with. Do you see that would enhance plea deals, and would a defendant ever fall off of a felony and go to a misdemeanor?
Every county does things differently.
Yeah,
In
I
our
realize
county,
it, yeah.
we have people plead to the charge. That's what we prefer, plead to the charge. If they want a sentence bargain, they can sentence bargain. When I was a defense attorney, I had an issue with the mandatory minimums because typically, if it was 50 or under, we're dealing with low-hanging fruit. A drug addict would actually get the drugs, he'd take a little bit off, and I actually had clients that knew that they were dealing with an undercover officer because they'd been arrested by the officer before. So they'd buy the drugs just because they wanted to hit themselves. They'd scrape a little bit off the rock of crack cocaine, so they'd smoke it themselves. They got their drugs. So we were dealing with a situation where we're getting low-hanging fruit. But we're dealing with a different situation now because fentanyl is really, I mean, people are dying. And people know that they're dealing this drug. As far as misdemeanors are concerned, I don't see misdemeanors coming out of this, but they can't. There's a use statute, but I want to say the use statute is a 2-year for Schedule 1. I'm not sure, but I don't see misdemeanors coming out of it, no.
One more quick question. Do you find that defendants have enough funds to pay off the fine that's being assessed?
They typically, the fine has to be proportionate to what somebody can afford. They can't just fine somebody who doesn't have any money. Typically, if they're on probation or something like that, they have time to pay off the fine. And under Michigan law, you can't lock somebody up for being poor. If they don't have the money, all they have to do is show that they can't pay it. Thank you. Okay.
Representative Johnson.
Thank you, Mr. Chair. Thank you for your testimony, and thank you for doing the best you can in a horrible situation. And you're honoring the life and the horrible death of your sons by helping us better our society. Thank you. My question is about drugs that are not narcotics, opioids, etc. Have we seen them possibly laced with fentanyl also, and it's coming in the form of an antibiotic or something real simple like that.
Well, I haven't seen that, but I've seen xylazine. Xylazine and fentanyl seem to go together. But xylazine is a non-opiate, and it's basically it's a tranquilizer for animals. And Narcan doesn't work on xylazine. So you have fentanyl, you can be saved from fentanyl, but you can't be saved from xylazine.
But you're not seeing it in other
I'm not seeing
types
it.
of
No,
drugs?
no,
Okay.
no. We'll have kids who think they're taking ADHD medicine, and it'll be a fentanyl pill instead, and that's causing death. But we're not seeing things like an antibiotic or something like that laced with fentanyl. The whole idea behind fentanyl is to get you high, and the medicine, whatever medicine you're using, that medicine is supposed to stimulate you in some way, and the vitamins, we have not seen it. No.
Okay, thank you. Seeing no further questions, I want to thank everybody for their testimony today, and the committee will go at ease.
Call the meeting back to order. I have a card of support from Matt Saxton of the Michigan Sheriff's Association regarding House Bill 4255 and 4256. Supports the bill, does not wish to speak. Okay, with that, looking around, I am going to have Vice Chair Bagol move to excuse absent members. Hearing no objection, absent members are excused. All right, seeing no further business before the committee is adjourned.